All right, hello and welcome. I'm Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C, where we fight for your American dream. And the following video, I want to show you what goes into a practice run, right? I'm just practicing here. This is not the real thing yet, for a Ninth Circuit oral argument. And so check it out, enjoy, tell me what you think, all right? Basically, when you're in front of the Ninth Circuit, you want to prepare, you want to know your arguments inside and out, you want to be ready to discuss it, and you want to be ready to answer back if the court has any questions, because you're operating at a very high level for a legal case. So you want to know the facts of the case inside and out, and you want to know all the law involved, and hopefully I demonstrate what our position is in the following video. Check it out. Again, it is just a practice run. So, but this is part of the preparation. The idea is just to kind of bring awareness to what goes into preparing for oral arguments before the Circuit Court of Appeals. All right. So thanks a lot. Enjoy. Bye-bye. Hello and thank you. My name is Otis Landerholm. I'm the attorney for the petitioner who is here in the courtroom. And we will be reserving 2 minutes for rebuttal after our argument, and I really appreciate being here today. May it please the court, we petition this court to review the BIA's decision denying our motion to reopen based on 3 issues. First, whether the BIA erred in denying our motion to reopen based on changed country conditions in Cameroon. Second, whether the BIA erred in denying our motion to reopen based on the ineffective assistance of prior counsel. And third, whether the BIA erred in denying our motion under its sua sponte authority. First, regarding changed country conditions, the BIA said that we, in our motion, had failed to show evidence of a qualitative change in country conditions in Cameroon between 2008, when our client had his individual hearing, and 2019, when we filed the motion to reopen. We disagree. With our motion to reopen, we submitted over 200 pages of country conditions documents showing a substantial and qualitative change in Cameroon. We showed that there was a sharp increase in human rights violations, in extrajudicial killing, in unlawful and arbitrary detention, and in torture in Cameroon. Okay, and so so much so that even President Trump issued an order terminating and removing Cameroon from the African Growth and Opportunity Act. Okay, no longer providing economic support to the government of Cameroon, citing gross violations of human rights, including arbitrary and unlawful detention, killing, and torture, even by Cameroonian government officials. Okay, and so to say that we failed to show a qualitative difference is error. We ask this court to please review that decision and reverse it. Additionally, the BIA is saying, hey, look, it was bad then and it's bad now. It's Paul Biya is the president of the country of Cameroon. He's still in power. It's still his people. It's not a qualitative difference. But here's the thing. The situation in Cameroon has gone from bad to worse. And when you go from bad to worse, yeah, it's been bad, but that is a difference. And so because of that difference, because of that change, there is changed, documented, changed circumstances that materially affect our client's eligibility for asylum that warrant reopening his case. That's it. Now, the government has relied on the case of Tufigi, all right, saying that, hey, the changes, whatever changes have happened in Cameroon, even if they have happened, they're not quote unquote material. But reliance on the Tufigi decision is incorrect. It does not apply in our case. The reason is because the Tufigi decision says that, okay, there was evidence that there was changed country conditions on how the Iranian government in that case was treating Christians. But in that case, there was a finding by the immigration judge that Mr. Tufigi had not actually become a Christian, had not actually converted to Christianity. And so they said that the evidence of, change country conditions to how they treat Christians is not material to Mr. Tufigi's case. Well, relying on that case makes no sense in our case, because there's no finding by the immigration judge that our client didn't belong to the Anglophone region of Cameroon. There's no finding by the immigration judge that our client doesn't belong to the Ngembe tribe. There's no finding by the immigration judge that our client doesn't actually participate or have anything to do with the Southern Democratic Front, the Social Democratic Front, or the Southern Cameroon National Council. Okay, and so there is undisputed evidence that our client was active in political organizations in Cameroon, and that our client was actually a member of those parts that would be targeted. All of the evidence that was provided in our motion to reopen showed the change in country conditions for people from the Anglophone region in Cameroon. And that is why it's material. All right, which is exactly why the government's reliance on the Tufigi decision is not correct. It's unavailing. It's inaccurate. Okay, I want to move to our second issue. Our second issue regards the ineffective assistance of counsel. The case Lynn versus Ashcroft says, and it allows for reopening when an attorney is, quote unquote, woefully unprepared at an individual hearing. And that's what we have here. Okay, we have showed that the previous attorney in our case failed to provide a declaration, failed to provide or advise our clients regarding witnesses, okay, failed to review and provide corroborating evidence that existed, okay, failed to do a psychological evaluation that our office did in conjunction with our motion, failed to review and provide evidence that was submitted as corroborating evidence, failed to advise regarding interpretation, all right? And all of these things were to the client's detriment. Really, she failed to prepare. All of it is like failing to prepare, failing to communicate with the client. These go back to like the duty of competence, the duty to communicate that are built in to the fundamentals of attorney representation. And so her failure to do that. So the other thing is the government alleges that, and really the BIA's decision too, says that, okay, even if there was the quote unquote ineffective assistance, it didn't prejudice the case. But they're misreading the Strickland versus Washington standards of what prejudice is, okay? Just showing that there's ineffective assistance doesn't automatically lead to prejudice. That's true. But you don't have to show the extreme level that, okay, all of this stuff, all of these failures, all of this bad, ineffective work, like absolutely caused, right? Absolutely caused the case to be denied. You don't have to show that if it weren't for that stuff, the client would have won. You don't have to show that. All you have to show prejudice is that it may have led to a different outcome. And the may have led to a different outcome standard, which is set forth in Strickland versus Washington, is what matters here, is what governs here, all right? If the attorney had provided a declaration, that may have led to a different outcome. It may have, okay? If the attorney had provided additional supporting evidence, testimonies, witness, declarations, at least from other evidence that corroborated the client's statements in the hearing, even a psychological evaluation to provide additional support and corroborating evidence of what was stated in the hearing, it could have fixed, it may have led to a different outcome. And because of it may have led to a different outcome, it needs to be reopened and that is prejudicial ineffective assistance. Our third argument is that the BIA erred by failing to reopen under its sua sponte authority. Okay, so here, the cases Menendez versus Whitaker, Bonilla versus Lynch, Singh versus Holder, they all rely on whether or not the circuit court has jurisdiction to even review a sua sponte finding. And they all, each of these cases, stand for the fact that, yes, the circuit court does have jurisdiction to review a sua sponte denial only if there's a showing of either a legal error or a constitutional error. Okay, and here we have a legal error. The BIA said that, okay, the reason we're going to deny it, they had a one-sentence decision. The reason we're going to deny it under our sua sponte authority is that the positive equities did not outweigh the negative factors in the case. Okay, so we declined to reopen in our discretion. But okay, what positive factors? What negative factors? All right. I mean, yes, there's the negative factor that our client entered the country without a proper passport and without a proper visa. Yeah, that's a negative factor. Okay. What other negative factors are there? There were arrests from the past, but they were all dismissed, right? Is that a negative factor? There was a quote unquote adverse credibility finding that we've provided evidence for was caused by the ineffective assistance of prior counsel. Is that a negative factor? Like, what negative factors are they relying on versus the positive factors? He's married to a U.S. citizen. He's been in the United States for almost 20 years. He's for more than 20 years, excuse me. He is, he has 2 U.S. citizen children. He's documented that his U.S. citizen spouse would suffer extreme hardship if he were, removed from the United States, and relies on him for income and everything else. Like, where is that analysis? It's missing. And the other legal error here is the BIA in its decision cites to the matter of SYG, saying that they're, quote, not inclined to favorably exercise discretion where an alien previously offered incredible testimony. But here's the problem with that. They're relying on, and the matter of SYG, they're relying on, quote unquote, incredible testimony that was very likely caused by the ineffective assistance of counsel, and that we've shown evidence was actually due to the ineffective assistance of prior counsel, as opposed to due to, actual misrepresentation in court. And so, in fact, the whole adverse credibility finding stemmed from one document, and it's an inaccurate document that was provided by the government of Cameroon related to a death certificate of our client. All right. So there's an inaccurate death certificate from Cameroon. I hate to say it, but is that so surprising? Is that so unheard of? I don't think that is that unheard of, quite honestly. And I think that an attorney could have showed evidence, right? That, hey, sometimes documents aren't that reliable from some parts of the world. All right. Unfortunately, I wish that weren't the case. Death certificates from the 1990s might not have followed the same level of scrutiny and accuracy. They might not have the same standards that maybe they do today, or that maybe they do in other parts of the world. And so saying that one document now taints and now causes a adverse credibility finding for everything else that seemed to be accurate and consistent throughout the testimony, even though it was done in a language that wasn't the native language of our client, I just think it's error. And I think there's legal error for the BIA to rely on that decision, especially when there's evidence of ineffective assistance of counsel. That's all I've got. Thank you so much for reviewing this case. We ask and petition this court to review, remand for further proceedings, and reverse when applicable. Thank you so much.